most of all, I'm sure everybody's familiar with our student scholarship organizations. These are organizations funded in Georgia by an income tax credit. It was originally created with a $50 million cap that has a consumer price index escalator. The number is just over $53 million annually that are available for taxpayers to designate to SSOs. The Student Scholarship Organization then awards scholarships. The maximum amount of that scholarship cannot be larger than the average expenditure on public school students in Georgia. Right now, that's, I believe, just over $9,000, but I don't have that number in front of me. It turns out that the average scholarship appears to be closer to $4,000, between $4,000 and $5,000 in Georgia's experience. This is a school choice project, and we are proud of the progress we've made in Georgia in this respect. And the governor is bringing this proposal to help add transparency and accountability to the way we do it. We have a lot of great organizations in Georgia, and we think they're doing good things for Georgia students. We want to make that transparent. We want to make that visible to the public, and we also want to address some issues that have cropped up in some of the smaller organizations that have given some pause to how these organizations work. So that's the genesis of the legislation. Section 1, the changes that are proposed to law in our bill is when this bill originally passed, it had an enrollment requirement for students to be in public schools. The idea being that we are going to, by implementing the SSOs, take students who are in public schools now and give them the option to opt out. In other words, that's the purpose, is not to provide funding for folks already in a private setting. That's not the original intent of the legislation. It's not the way it was sold. So it had the enrollment requirement. In practice, on a few occasions, it appears that people would enroll and then never show up. And so the intention with this paragraph on section 1 is, you'll see on line 16, there's an attendance requirement of 6 weeks, so that we have folks that actually give an opportunity in the public school setting before moving out under a scholarship. That is, if you look to the bottom of that paragraph, there are exemptions to that. The committee, this is one of the changes that you will see in the proposed committee sub. The first 2 exemptions to the attendance component would be that if you are attending a school that is a failing school, if that's where you're designated to go, or what's here called a low-performing school. That's the school reports that we will see next year out of the Governor's Office of Student Achievement. So if you're attending a school that's a low-performing school, we would not make you attend that school. So on that line 25, we would insert an "or" before the word "to" get the second exemption, which is someone who has documented cases of verbal or physical abuse in a public school setting. We would not anticipate them having to stay in that public school setting for 6 weeks. If they're being mistreated, they could immediately move on to a scholarship program. The committee sub that we have to propose would then put a period on the end of line 26 after the word "harm" and strike what was a last exception that was passed through the Senate. The concerns were that the exemption for religious beliefs was overly broad and unintentionally created a natural preference for religious-based schools, and that was not the purpose of the SSO legislation in the beginning. It was school choice in general, not to say that one category of private school would have preference, and so that's where that change will be. Looking into section 2, Mr. Chairman, the current law, state of the law, is that SSOs designate 90% of their revenues to scholarships, and so you have 10% for operating expenditures. The best practices, and we've got a lot of great organizations, some that you'll hear from today, are already exceeding that amount by substantial, measurable sums, and that's a good thing. In other words, more dollars are going to scholarships. What the governor's proposal is in this bill is that after $1.5 million in revenues, if they have in excess of $1.5 million up to $10 million, that they would designate 93% of their revenues towards scholarship funds, and if they are in excess of $10 million, then they would hit 94. In excess of $20 million would be obligate 95%. of their revenue.
So just an economies of scale?
That's correct. The balance of that section, Mr. Chairman, deals with how they're allocated, and some of the issues that have come up is multi-year allocations. And this was a question in the Senate about how that works. Well, if a student is going to a private school, and perhaps it's to go in for a middle school or go in for a high school, it's very difficult for a family to make a true school choice if it's a year-to-year proposition. It's also challenging for the Student Scholarship Organization in terms of their ability to award a true scholarship if they don't know whether they're going to have the money next year. So when we talk about that allocation of 90, 93, 95%, and so on, that allows for multi-year scholarships, and that works in one of two ways. Either the Student Scholarship Organization internally creates a designated fund that says, Representative Pack, you got a scholarship for 4 years of high school. We pay you out the first year. The next 3 are held in this segregated fund. Those count as designated for that 90% threshold. Alternatively, they enter into an agreement with the school, and they front all 4 years to the school under the understanding that Representative Pack has a 4-year scholarship. And so we're just making it clear how that works, and part of the provisions that you'll see, trying to find the exact line from that from mine. That's correct. There's essentially a clawback type of model where we would say that if a student for any reason doesn't go in future years of a
60-61.
That's right. Yes, sir. So if they don't go for any reason in those future years, those funds, if they're in the designated account at the Student Scholarship Organization, they flow back into their account, and they've got 1 year to redesignate them to a new student for scholarship. If they have been sent out to a school, rather than put a burden on private schools, we're going to require that student scholarship organizations that engage in that practice, in their agreement with the school, have the same provision that the dollars would come back to the student scholarship organization. Moving forward on to section 1.1, this is a new provision to the law, and this is a provision that requires our student scholarship organizations to consider financial needs in making their analysis. There's no requirement that they give preference or that they establish any sort of quota or means-based testing, but it does require them to consider the financial status. There will be an amendment or a change in the proposed committee sub, Mr. Chairman, on line 78 and the first word of line 79. We would just propose striking that. That's a specific measure of how we would consider a family financial need, and rather than have a specific measure in statute, we would like for the SSOs to have the liberty to consider financial income as adjusted for family size using any appropriate measure. That is to say, they don't have to use any one specific measure.
Exactly what you would change.
So at the end of line 77, after the word size, we would just place a period there, strike all of line 78 and the word development on line 79, so that we're not dictating to them what measure to use. And again, the idea being is as a school choice program, the folks who are least able to choose what school setting they're in are those with the greatest financial needs. So that's where that comes from. We believe good public policy in Georgia is that SSOs should be considering financial needs. That doesn't mean it should be dispositive. It doesn't mean that there aren't other overriding factors that can't go into consideration in any given student. And we are not by any means trying to propose a matrix or a weight, but we do think that the good public policy is that as part of their consideration, they would consider financial need, given that it is a school choice program. And for it to be a true school choice, it has to be somebody who does not have that choice today. If we're promoting choice, we should be promoting it for people who don't have the choice in the current world. And obviously the people most in that category are people with limited financial resources. It's the intent that these scholarships be arm's length transactions. And current law, as you can see, which is on line 180 and 181 down through 182, is that you're not allowed to take a credit and make a contribution that is earmarked or designated for your dependent. You would be taking what is today a deductible education expense and converting it to a tax credit. So that you can't do that. And so what the language we're proposing is that you would not be able to direct it to any particular individual, whether a dependent or not. Again, this is not what is happening with the best practitioners in Georgia, but we do have some indication that there are instances where, they say, hey, Representative Carson, you make a contribution for Charlie Bethel's son, and he'll make a contribution for your daughter. And this is, we don't think that's happening in our, but we want to make clear that that's not the way this is supposed to be done. And then
You do designate which school would benefit from.
you can absolutely do that. That's right. You can. That's right. And SSOs operate in different ways. Some do not have affiliations with schools. Some have affiliation with one school. Some have affiliation with multiple schools. And you can. That is correct. There's no reason why you couldn't say we want to earmark this for a fund. My father went to Darlington School in Rome, so you could say I want to designate it for a fund that provides scholarships at that school. Totally fine. But you can't say, I want it to go to this person, whether they're your dependent or not.
Even if, for example, you might have the rug manufacturing company that donates $50,000 in this program, but you can't direct it to go to only employees of the manufacturing company. Children.
I would not view that as prohibited by this language. That
Really?
it's not a particular individual.
Okay, so it could be a group of people, but not, you couldn't
You
specify.
can't designate a recipient.
Any other question? Representative Carson?
Does this bill require a fiscal note, and if so, has one been done?
It does not require a fiscal note. It's not a fiscal bill because
It's got a cap.
It's already got
we don't
Okay.
touch the
You don't touch
fiscal
the overall?
provisions.
Okay.
Yeah, current law is a $50 million
50.
cap with an escalator.
It's up a little over $53 million, but we don't, that's already where it is, and none of our amendments would change that.
Okay. Thank you.